After more than 2 decades of negotiations between states and indigenous peoples, brokered by the United Nations, on 13 September 2007, the General Assembly adopted the UN Declaration on the Rights of Indigenous Peoples. This was a day of historic significance, with the declaration having political, legal, moral, and symbolic implications. There were 2 main interlinked difficult issues for states in the process of drafting the declaration: the right to self-determination and the right to lands, territories, and resources, especially natural resources. The declaration is imbued with an elaborate legal articulation of human rights that spring out of these 2 ideas. The declaration clearly recognizes individual and group rights. Group rights are recognized in various domains, such as the choice of modes of development, administration, education, health, and others. The declaration is aimed at outlawing and repairing historic and systemic discrimination against indigenous peoples. The text says that indigenous peoples and individuals are free and equal to all other peoples and individuals, and have the right to be free from any kind of discrimination in the exercise of their rights, in particular, discrimination based on their indigenous origin and identity. The declaration requires new approaches to global issues such as development, diversity, and pluricultural democracy and peace, and encourages the building of genuine partnerships with indigenous peoples. In the declaration, there are 9 preambular and 15 operative paragraphs dealing with consultation, partnership, and participation of indigenous peoples. The declaration recognizes that indigenous peoples have the right to self-determination. By that right, they can freely determine their political status and pursue their economic, cultural, and social development. They have the right to maintain and strengthen their distinct political, legal, economic, social, and cultural institutions, while retaining their rights to participate fully, if they so choose, in the political, economic, social, and cultural life of the state. For indigenous peoples, the right to self-determination has meant decolonization, survival, and well-being, and it is the cornerstone of their existence as peoples. The non-recognition, subversion, and bold destruction of indigenous governance systems has been a major way that states have tried to dominate, assimilate, and erase indigenous peoples over time. As we mentioned in Module 1, in the early days of the interface between the indigenous peoples movement and the UN in the 1970s, states were expressing some humanitarian type of attitude for what they saw as fast vanishing populations in the process of assimilation. This was also the attitude of states within the context of the International Labour Organization when, in the 1950s, a study of that organization revealed the slavery-like situation of indigenous peoples. However, for a long time, states did not want to accept that indigenous peoples are peoples under international law, with a sense of their common past and a vision of their common future as groups, and who have had and still have their traditional or not, and in any case evolving governance structures. For example, the Haudenosaunee Confederacy of the Six Nations, living in what is today Canada and the USA, claims to have created the first Confederate Constitution in the world. And Chief Deskahe, who was the first to go to the League of Nations in 1923, as was discussed in Module 1, was from that confederacy. Indigenous peoples' governance systems were and still are systematically undermined by many states. The discussion on indigenous peoples' right to self-determination also reveals the violence of law vis-à-vis indigenous peoples. The violence of the colonizers, the oppressors' law that indigenous peoples as collectivities faced over the centuries has taken many shapes. One example is the lack of any significant reference in the UN's constitution and its amendments to indigenous peoples, except in a clause on commerce. and the lack of any reference to the fact that this country was created on indigenous peoples' lands. This deliberate legal vacuum was there, despite the fact that the USA and Canada continued concluding treaties with Indian nations until the beginning of the 20th century, thus being fully cognizant that indigenous peoples are peoples with their own governance systems. The doctrine of discovery, giving colonizing powers from Europe the justification to seize lands not inhabited by Christians, continues to be applied in USA courts, while other more positive court decisions and precedents occupy a lesser position. Another example of the violence of the law of settler colonialism has been the concept of terra nullius, empty land, imposing legal invisibility or erasure on indigenous peoples as peoples, and even as human beings. Connected to this have been two other common state practices. One, indigenous peoples have been considered as minors under law of various countries, for example, as not having full legal personality. And second, in other cases, they are deprived of citizenship. More often than not, their existence is not even mentioned in the national constitutions and laws. And more often than not, they do not appear in national statistics. It is, for example, by just a simple stroke of the administrative pen that the Russian Federation decided to stop counting ethnicities in recent censuses, despite disagreements of indigenous peoples. Let us mention, as part of the legal imposition of settler states vis-à-vis self-governing, sovereign indigenous peoples, the fact that in 1924, the USA conferred citizenship to all the indigenous peoples via the Indian Citizenship Act. Various indigenous nations did not wish and still do not wish to have this citizenship. For years, even to this date, many citizens of the Haudenosaunee Confederacy of the Six Nations have refused to travel on USA or Canadian passports. They travel with their own passport now accepted by 22 countries. The UN system too, still today, in its various practices, has difficulties understanding that indigenous peoples have to be dealt with as self-determining peoples with their own governance structures and not as anonymous peasants. Various UN guidelines, plans of action, and training efforts are meant to create a normative and operational culture so that the UN will respect indigenous people's own governance systems and their free, prior, and informed consent in UN operational activities. Professor James Anaya, international law expert and former UN Special Rapporteur on the Rights of Indigenous Peoples, has stressed the human rights aspect of self-determination for indigenous peoples and has pointed out that in the case of indigenous peoples, the right to self-determination as a human right also has remedial, in other words, moral aspects that can address historical injustices.